I just pressed the Let's Go Live button. It has been a few days, and we know what that means. Sometimes there's cobwebs stuck in the inner tubes, and we don't like that to happen. We like to make sure the tubes are cleared out. Any leftover feds in the tubes, it's time to go. Okay, we need to use them again. Stop hacking our tubes. It looks like they are working. That is tremendous. That means we can go ahead and get started as soon as we press that button and that button and that button. And now we can do it. Oh, by the way, on Rumble, I do not think it's working. Okay, I had 2 Rumble problems. Okay, there are Rumble tube problems. So we are not live on Rumble today. Yep, we are not live on Rumble. You can see I tried to schedule it twice right here. And this is where we're supposed to be. 17 minutes ago, I tried to schedule this puppy twice, and so we are not live on Rumble today for whatever reason. There you go. So that's what it looks like when I scheduled on Rumble. Tried it the first time. It's still scheduling. Tried it the second time, and the video is not found. So, all right. Anyways, so that is what's cooking over on Rumble. Yeah, not going to be over there. It's not working. So not sure what the dealio is, but our Rumble friends will re-upload all the stuff after the fact. And so we're not going to be live there today, but we tried. All right, so we are going to get to it. Other than that, the other tubes are working. So let's go ahead and get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Judge Engoron's GreenField. She got busted, man. Now, she's already been busted a few times here, but another video dropped, and it's of her at a rally, and they're talking about how amazing Joe Biden is and how terrible Donald Trump is. And of course, this is Engoron's clerk. This is the woman who is in the courtroom, who is working on the case, sitting next to the judge and talking all about the case to the judge, whispering little love notes to him. Who knows what else she's doing under the table, under the bench there. It's, you know, something we don't want to even talk about. But this video popped out of her, and you can see her right there taking photographs, having a drink. She's having a lot of fun at all these various rallies. She's already made thousands of dollars of donos to lefty organizations. She's worked, it sounds like, with people like Jerry Nadler, who was also on the first Trump impeachment, and so on. And we're going, oh my gosh. So the story goes on and on. It's like, no wonder they wanted Trump to be gagged from talking about this. And we'll get into it. We also are going to talk about Trump and his reply. So Trump filed a reply in the Court of Appeals, in the New York State Court of Appeals. And we'll see what that says, because they also articulate why everything that the judge has basically done in this case is insane, right? They want a gag order on Trump. Trump is wanting that gag order to be removed, or in this case, stayed, limited, while the appeal is pending. And we'll take a look at what that filing looks like there in our first segment. Then we're going to turn our attention to what's going on in the Washington, D.C. case. We've got a nice motion, nice meaty motion to unpack here. It is a 25-pager, and it is discussing the constitutional basis for why Trump's case should be dismissed. In other words, the First Amendment protects Trump. Everything that Jack Smith alleged in the indictment is non-criminal because it is protected under the First Amendment. And we're going to go through it. This is Trump's final reply. So remember how this goes. They make the original filing, then Jack Smith responds, then we get a reply like a sandwich, and this is Trump's final reply. And so we'll take a look at that. Then it's going to be off to the judge for a ruling into Judge Chutkan's chambers. And then lastly, we're going to see what's happening with Jack Smith and the gag order. Now, because the gag order is not in place currently. And so over the holiday weekend, and I hope you had an amazing Thanksgiving, my friends. I had 2 amazing Thanksgivings, but we had Trump on the tear on the 23rd, and he was saying, happy Thanksgiving to all. And then he went on to talk about Peekaboo James. He went on to talk about Psycho Engoron. He went on to talk about the chief clerk, GreenField, and other things. And then we'll see Jack Smith was unhappy about that. He's saying, hey, Court of Appeals, Donald Trump's talking garbage again. And they said that that type of garbage is causing all sorts of nasty voicemails that's making them quiver in their little pantalones over there and in New York. And so we're going to go through that. Jack Smith sent a little tattletale letter over to the Court of Appeals, and then Trump responded to it. He's like, okay, look, those messages aren't very good. Like, we don't endorse them, but it's not illegal. And it's irrelevant to this gag that we're talking about with Judge Chutkan in the DC Court of Appeals. So we'll see what that little back and forth looks like. It's pretty quick. And then we'll see what some of the people on MSNBC and elsewhere are saying. Do we have 3 clips from MSNBC? Did I clip 3 from MSNBC today? Oh my gosh, I did. All right, well, it's a Monday. We're back. You know, we got to just get through it. So we're going to hear from Judge Luttig, who actually might be a witness in the Trump January 6th case. We're going to hear from this other woman who says that the Trump voters have stopped processing what a maniac Trump is. She's like, we need to remind him what a monster he is. And then this lady is saying, you know, free speech is a nice thing, but when it comes to Donald Trump, we got to double down on it. We got to gag him because, you know, America's at stake and so on. And so, my friends, as you can see, we do have a lot to get to today. It's a beautiful Monday. I hope you had an incredible holiday, time off, spending time with family, the people you love, the friends in your life. I had a great time. I was traveling around. I was up in northern Arizona for a part of it, and then down in southern Arizona for the other part of it. Got to see a lot of people, and it was a beautiful time. And so we're feeling good. We're happy to be back. We're grateful that you are here and with us. We are looking forward to getting back on schedule. And this morning we had our members only stream at watchingthewatchers.locals.com, which is where we talked a little bit this morning. We got caught up. SCOTUS was doing some stuff. Congress was pretty quiet today. We poked around, kind of got our bearings straight. We know that Javier Milei's coming to visit. We know that Joe Biden and the polls are looking really bad for him. I think on election betting odds, we talked about this morning. Trump's up by 11 points up there on those aggregated polls from all over the place. We're checking 538. We're checking the dockets. We listened to some SCOTUS this morning. And so it's a lot of fun. Check us out, watchingthewatchers.locals.com. We do member streams in the morning. We have an amazing community over there. And yeah, Zach Nichols is saying, Rob, did you get to touch the snow? I did. I touched snow. I touched snow. And I'll tell you this, the snow touched me. That's true. All right. So watchingthewatchers.locals.com is where it came out, where our community is. And we also have the website, robertgovea.com, which is where you can sign up for our daily newsletter. So all of these segments, everything we're about to go to, all the PDFs, all the documents, they're all there. robertgovea.com. You can access this mind map there, sign up for the daily newsletter there. You can read the show reports there. There's a mind map tutorial there, and there's a lot more coming, and we're excited about it. So come check us out, robertgovea.com. All right. Now, with any further ado, let's get, yes, it was consensual. It was consensual. It was mutual touching, you know, with the snow. Yeah, it was mutual. Yeah. No, it wasn't a snowman or anything like that. No, it was just the snow. All right. Let's get to it, my friends. This is where we'll get started on the day. Engoron's law clerk, let's do that again. Engoron's law clerk, his principal law clerk, known as Allison GreenField, aka the judge's GF, has been busted. We've already talked a lot about her donos, thousands of dollars to Democrat funds. Some of these organizations were directly adverse to Trump or in support of Biden or in support of Letitia James. I mean, it was wild. And now there's this new video that came out, and we're going to take a quick look at it. Now, this came from this account I saw on the X platform known as Judicial Protest. And here's how they introduce it. They say, bombshell video of bias and misconduct on behalf of Judge Engoron's law clerk. Her name is Allison GreenField, just uncovered. Mistrial incoming. Now, I'm not so sure about that. We'll see what the Court of Appeals says about this. But, you know, we're kind of in New York, and we'll see how far and how much leeway they give to the judge. But they say, while attending an October 2022 Democrat fundraiser, GreenField can be heard saying, quote, Biden is the best president in the history of the United States. And of course, that means that if Trump is running against Biden, that she is opposed in an adverse position to Trump. Meanwhile, GreenField was front row at one of these events yelling, yeah, shaking her head in agreement and taking video of Democrat politicians as they bashed Trump. Now, this account, Judicial Protest, at Judicial Protest, recommended follow, I certainly have, says Alina Abba should demand that GreenField produce the videos that she took. And we've already seen this, right? She had an Instagram account and other social media accounts because she was actually running for office. I mean, she wanted to be a judge. Now she didn't get elected, and now she's LARPing as a judge, just live action role playing, like I'm kind of a pseudo judge. So she took a lot of those things down, I'm sure. Now they say, uncover those. Somebody should say, what else have you posted out there? Let's see if you're biased or not. The judge says now, we can't even ask about it, right? And to Trump's lawyers, do not do it, Chris. Don't you do it, Chris. Don't file it. Now, even worse, video shows GreenField campaigning, gathering signatures with Grand Street Democrats on behalf of Tishy Latish in her 2022 primary campaign. That's the prosecutor. That's the AG who's prosecuting Trump. She's sitting at the entrance of the event with a Diet Coke. It's not working. Oh! Yeah, keep trying. Gathering signatures on a green sheet of paper to get Letitia James on the primary ballot. Again, this is while the Trump civil fraud case was pending. Why aren't Alina and Christopher Keese getting to this in Engoron's face? Well, I'm sure they absolutely will. A couple websites there that this account, I think, is managing. But they put this together, man. Look at this. 2.9 million views on the X, and we love that. This is what it looks like. And you can see, here's the judge's GF, the judge's GreenField right there. Look at that. I don't know if that's a Diet Coke or what she's got. But here it is. And listen to what she says in this report.
Part of a Letitia James campaign event, one individual stands out. Hobo Judge Arthur Engoron's principal law clerk, Allison GreenField, is in the front row taking pictures as the candidates bash President Trump. GreenField's voice is audible, conveying criticism towards President Trump and his supporters. GreenField can be heard expressing, "Biden will be remembered as the greatest president ever." The video released shows close-up shots of GreenField capturing the moment with her camera.
I'm so proud of this administration. I will dare to say that Joe Biden will be remembered as one of the most consequential and transformative presidents in the United States. Yes. To gun law, to the chip bill, infrastructure bill, the Inflation Reduction Act, lowering prescription drugs, and student debt loans.
This is the most important election ever. It's true.
That's right.
We are engaged in an epic, maybe even generational fight against an anti-democratic movement, a dangerous anti-democratic movement, which has taken over one of the major parties of this. You're going to become a judge just because of that. I mean, no, right on cue.
You're going to become a judge just because of that. No, not true. And so they're going to explain this portion here. But look, I want to just highlight this because this video moves fast and it's, very nicely assembled. But this is her. And you can see right there, even the name tag says Allison GreenField. Oh, isn't that cute? The judge's GF right there. And then when we go over to this direction, who's this guy? Right here, all 4'6" of them, Jerry Nadler, the waddler, right? Waddling around Congress with that diaper. It's been in there for 35 years now. It's like 35 pounds. I don't know how much is in there, but a lot. But they're all there. You can see some people are trying to keep their distance, but not Allison GreenField, all right? She's cozying right up. She's very familiar with that. So she wants to get close to him right there in the red circle, right in the red square. Make sure you know your geometry. And we also have her tucked away back here as well. June 2022, while the case was ongoing. And these items were posted on Facebook. For Freedom Democrat Club NYC. Don't know if this was one of the donos that she made. She made thousands of dollars of donations to Democrats. Let's carry on.
In June 2022, while the People versus Trump case was ongoing, GreenField was observed actively campaigning with Congressman Jerry Nadler. As chair of the House Judiciary Committee, Nadler led the impeachment of President Trump.
Oh, convenient.
In 2022, GreenField was also spotted engaging in campaign activities for Alvin Bragg. In a quote, she expressed her general support for Alvin Bragg's policies.
I am generally very supportive of Alvin Bragg's policies.
Of course, because Alvin Bragg is the prosecutor in New York who is prosecuting Donald Trump. Now, this other photograph is from her. It says Grand Street Democrats primary rally, June 16, 2022, and stroll to the polls June 18, 2022. You can see she's tucked away right there with a bunch of people.
In June 2022, during the pendency of the People versus Trump case, videos depict GreenField's presence at a political rally supporting Letitia James. GreenField can be seen seated with a clipboard filled with signatures, actively involved in petitioning and campaigning for Letitia James.
Oh my gosh. She's actively campaigning for Letitia. Letish, the woman who sits in the back of the courtroom on that one podium pew constantly. She just sits there in that one row and, they're going to have to change the bench by the end of this trial because she's, wearing it out. But this is the judge's clerk who is sitting on the bench. Okay, so just visualize it. Tishy's back in the courtroom, not doing anything. She doesn't even speak. I mean, at least Fannie Willis in George's RICO case, at least she did something while she lost embarrassingly back during the Harrison Floyd bond trial that we covered last week. I mean, she gave it a shot. It was embarrassing for her, like this rest of the RICO cases, but, you know, at least she came up and did something. Tishy doesn't even do anything. She just sits on her Tishy back there in the bench. But here, she must be making eye contact with this woman who is actively campaigning for her with a Diet Pepsi, typical. And you can see she's collecting ballots, taking signatures here. Now, pausing on this freeze frame, right, here is this one. And we see, it's hard to make out the logo on this pink, you know, I don't know if it's the hats that they were wearing back in New York or whatever with the, you know, the holes in them. But this was her sitting there with the green signature ballots. Let's carry on.
Seated with a clipboard filled with signatures, actively involved in petitioning and campaigning for Letitia James. Is GreenField passing instructions and directives from Letitia James, Jerry
Yes.
Nadler, and Chuck Schumer to
Yes.
hobo judge and corrupt Democrat Arthur Engoron?
Yes.
What other reason could there be for hobo judge Engoron to issue a gag order on President Trump and President Trump's attorneys once this evidence emerged?
So that nobody
Breaking
can
in
talk
just the
about it.
last hour, the judge in the case has issued an expanded gag order, ruling that Trump's attorneys can no longer make any public statements in or out of court about communications between the judge, that's Judge Engoron, and his staff.
GreenField is exerting influence on the trial's outcome in favor of Letitia James, Jerry Nadler, and Chuck Schumer. Hashtag Justice for Trump. Hashtag Trump 2024. Attorney Allison Greenfield.com.
All right, so very interesting production there. And you can see even that last photo. GreenField for civil court. Okay, she was running for office. She didn't win. Now she's having to role play a judge. But when she was actually running, she had an Instagram account. She said, "So thrilled to attend the Chelsea Reform Democratic Club Founders Brunch today, honoring incredible and fearless lifelong public servants like Senator Schumer and Representative Maloney. Thank you for a fantastic event." 3 exclamation points. Wow. All right, so you can see, right, this is the clerk. This is the judge. This is Areola Judge Engoron, who's also blasting out in his high school newsletter to the Wheatley alumni that he's got bonus torso photos available for them. And also they should recognize that he is in the news, gagging Trump, and he's in the news, prosecuting Trump and holding, you know, Trump in different penalties, all sorts of things throughout the pendency of the case. So this is what we got from this great report from @JudicialProtest on the X platform. And of course, this is the subject of everything, right, in this case. Donald Trump has been making the argument that this case is biased, as obvious as, you know, can be. Not only do we have this judge making bizarre rulings, this judge has a history himself of being anti-Trump in his postings and so on, but Engoron's law clerk is also involved, and she's in cahoots with Tishy Latish. And so Trump is now going to file a motion in the appeal supporting the stay of the gag order, meaning the gag order is not in effect, and Trump is going to let that be known on his Truth Social soon. But he's asking for a stay of the gag order, and he is submitting a reply in the appeal. And so we're going to go into that right after a quick message from our friends. And now Trump files his reply in the Court of Appeals, and let's dive right into it and see what he says. This is a big filing, and hat tip to Elliot, our document master on locals, for sharing this with us. 1,900 pages, and this got dropped 11/27. And you can see this is the affirmation of Clifford S. Robert in further support of an interim stay. So just to be clear about this, Engoron issued a gag, said Trump violated it multiple times, gave him a warning, $5,000 sanction, $10,000 sanction, and so on. Trump appealed it. The Court of Appeals in New York, so remember, we're in the appellate division right now, but we were in the Supreme Court of the Supreme Court of the state of New York, which is where Engoron resides. And so we're out of his court. We're in the appellate division right now. And Clifford Robert is one of the attorneys who's admitted to practice in New York. He also represents Donald Trump and the rest of the Trump organization. And he says, look, I've got a bunch of additional stuff to tell you, Court of Appeals, including all of these different exhibits. So we'll go through this, right? It's about 1,900 pages. We'll fast forward all the way to the end to get the juicy nuggets. But let me just share with you what else is in this big document, in this filing, because we're expected to get a ruling from the Court of Appeals on the gag order And this is very much compounding. So think of this almost like dominoes. So in New York, the gag order was issued by Engoron because they were talking about this law clerk, and this law clerk obviously has a history of bias, not only donating to Democrats, not only working for Tishy Latish, has a strong history of anti-Trump bias, working with Nadler, anti-Trump impeachment guy, hanging out with Schumer, like anti-Trump extraordinaire in the Senate. And so it's a nonstop problem. So when they were commenting on that, Trump just made a comment about it. The lawyers were making comments. They got gagged, right? And this gag was the basis for mistrials. Now we're in appeals. And the gag in New York has also been used in D.C. So Jack Smith's prosecutors are saying, see what Trump is doing, Judge Chutkan? You don't even have to see evidence of actual harm from Trump's speech in the D.C. gag. All you need to do is look at the New York gag and use that. And so they're compounding. They're all playing off one another. And this is all by design. So they're submitting more. We'll see what the Court of Appeals does. Clifford Roberts says there's additional filings here. We're going to drop all the way down to the 1800s and see what the actual meat and potatoes looks like. Because just to give you some highlights and save you some of the scroll, a lot of transcripts are in this document. As we just keep going down, you see we're fast forwarding through a bunch of transcripts before we get to the actual meat and potatoes. And let me save you some of the scroll before we get there. And here we are in the document. Boom. This is petitioners Trump's memorandum of law in further support of the stay of the gag. So you can see Clifford Robert, the same guy who signed that affidavit on the front page, is also joined by Alina Abba. And so they're here submitting this with a table of contents and a nice filing, and let's go into it. They start off, they tell us, all right, Court of Appeals, guess what? Donald Trump moved for a stay. We wanted to limit the gag order for further enforcement of the gag order in an attempt to redress Judge Engoron and his brazen, unmitigated violations of the Constitution. Not only the Constitution, but the New York Constitution, judiciary law, and the rules of this court. The notion that an openly and overtly partisan individual like Engoron would have any role in the decision-making process of this unprecedented case runs squarely counter to the foundational principles of American judicial independence and the constitutional guarantee of a fair trial. Like, you want the judge in a case like this to be as neutral as humanly possible. If you even have a whiff of bias, you got to go. Because it's a political case. It's a charged case. You have to think about legitimacy as a variable in the justice system. Look, you might think, you have to think about this, right? And this is what for example, Judge Roberts did. When Judge Roberts did something that I found detestable, but I understand it, was crafting Obamacare as a tax. If you remember that, just to take a little tangent here. We were all sitting around going, there's no way Obamacare survives the Supreme Court, but it did. Because Judge Roberts, who we thought was this conservative hero, came out and finagled it, right? We're going to rewrite all this to make it work. Why? Legitimacy. He wanted to save the legitimacy of the court, because if he didn't do that, and you might disagree with that, which I do, that he could have, right? He says if he would have gone the other way, Obama just came sweeping in and the country was all enamored with this new president. And if they would have gone against that, it would have shattered the legitimacy of the court. Take it or leave it. That's what I think his justification for it was. Nobody thinks that Obamacare is a tax. So they made it work. They made it fit, right? My point is, these pieces work together to create legitimacy. And in a case like this, you want legitimacy because even if you convict Trump, nobody cares because they think it's illegitimate. So this whole, dog and pony show, everybody goes, who cares? Okay, indict him again. Nobody cares. His polls keep going up because you're illegitimate. And so, all right. And, it's why it's not that concerning, quite frankly. Indict him again. Indict him again. Make it 100 charges. Make it 200 charges. Who cares? Because the DOJ, FBI, Judge Engoron, and Allison GreenField have all proven themselves untrustworthy and illegitimate and lacking in credibility. So that's what it is. Now, indeed, they say this is why the Judicial Code of Conduct prohibits judges and their staff from engaging in partisan political activity. Kind of the point. But here, the sweeping unconstitutional gag orders which restrict both Trump and their lawyers' speech, have impermissibly abrogated Trump's First Amendment rights to demand basic fairness and to highlight to the public the very open, public, and partisan conduct that has infected and permeated this trial. In some Court of Appeals, Engoron's gag orders shield the judge and his openly partisan clerk from the precise scrutiny essential to maintaining public confidence in the judiciary and ensuring a fair trial. It's gone. Like, this case is gone after we learn more about this clerk and this judge. And we'll see what the Supreme Court says. I mean, it's getting worse by the day. Now, the Supreme Court has ignored with impunity clear and troubling evidence of partisan political bias, and in doing so, undermine, they got it, perhaps irreparably, the rule of law. You think they're going to just like change the judge and we're all going to, okay, this is a legitimate case? I don't think so. It's pretty much done. Now, respondents now urge this court to inflict petitioners constitutional injury anew, meaning Trump has already been injured, and you're going to do it again, by vacating the interim stay and bestowing upon Judge Areola an absolute unfettered power to punish Trump for validly objecting to demonstrable partisan bias on the bench. And again, she's sitting there like on the same level, talking to him constantly, and he's admitting that. Like, this is not the defense making it up. He's saying, I'm allowed to talk to her as much as I want. Dang it, leave me alone. She's a babe. At stake is a civil defendant, Trump, and front-running presidential candidate's ability to critique without fear or reprisal the court presiding over a bench trial of historic proportions. The court should reject the government's invitation to error and protect the bedrock rights undergirding the legitimacy and the integrity of the judicial system. They say Donald Trump's free speech interests are anything but, quote, vanishingly slim. They say Trump is into the second month of a trial that the world is watching. It carries serious implications for the limits of Tishy's power and equally grave consequences for Trump's personal business and his interest in this state. Every day, Trump must defend himself before a, quote, de facto panel comprising Engoron, who's already determined that Trump is not credible, already levied 2 unlawful contempt sanctions against him. And rewinding that for a minute, when we talked about this, they were saying the judge, the form of his penalty was not even lawful. It's like, where do you have the power to issue this contempt charge? Where does this come from, Judge? The unelected principal law clerk, because she tried to run and failed, who openly supports and donates to Democratic figures and organizations that have declared President Trump their avowed political enemy. And yeah, it says Engoron appears in this proceeding through Lisa M. Evans, a deputy counsel in the court administration of New York. Anyways, more fundamentally, though, Trump's interest in raising the issue of bias on the bench with Engoron, it implicates a touchstone of the American constitutional framework, which is, namely, the ability to criticize government officials without fear of reprisal. The First Amendment. Supreme Court's disapproval, Engoron's, or disagreement with Trump's speech, or the fact that a third party may respond to it in some abhorrent way, do not justify putting that principle at risk. Just because you get bad voicemails doesn't mean you get to gag someone. If it is to have any meaning, the First Amendment must protect everyone, including Trump. And any enforced silence will doubtless engender resentment, true, suspicion, and contempt more than it will enhance respect, which has been the point from day one, right? If Trump is such an insurrectionist, it's obvious to us. Just release the videos. Just release the January 6th footage. We'll see that it was all orchestrated by Stuart Rhodes and not Ray Epps or whatever, right? We'll see it. If the evidence is so damning of the documents case, why don't you show us what's inside? No, you can't do it. It's all skiffed up. It's all, locked down. They won't tell us anything. Trump's gagged in the January 6th case. Trump's gagged in the New York case. Let him talk about it. People are pretty smart. They can understand if it's reasonable or not. And obviously the digging has occurred in this case with the law clerk, and she's clearly biased. So instead they say the gag order stops Trump from making any in-court or even extrajudicial statements about the staff, including the principal GreenField, regardless of the content. And the government says they do not, because they cannot, rebut Trump's factual allegations regarding her partisan and political activities. What is there to argue about? It's on her own Instagram account. We got the screenshots. Open support for Democratic candidates and causes, and has demonstrated literal antipathy towards Trump during the pendency of this case. This wasn't 5 years ago. The Trump case was in trial or in pretrial, and contributions well in excess of some of the permitted code. So the Judicial Code of Conduct says you can't actually make donations over $500. And the judge did some bizarre, like, carbon credit math calculation that I don't understand, where he said, oh no, but the ticket that she bought to go to the thing can be discounted from the total cost of the donation. And like, she stayed at a hotel and went to a fast food restaurant probably multiple times. And so it deducts that from the rest of her bill. And so the judge came to some calculation, didn't give us any receipts, didn't tell us how he came up with those numbers or why it's under the $500 other than some loose explanation. Yeah, she's permitted. She's allowed to do that. So it's clear now, and it's all on record, like FEC records, right? We've got the documents. Nor do they dispute that she sits on the bench with the judge, has been repeatedly photographed at the judge's side with his permission, rolls her eyes at remarks by Trump lawyers, and constantly whispers and passes little love notes to Judge Engoron while the parties are on the record. Here, hey, baby, here. And I don't know if she's kicking him in the foot or what. You know, those benches are pretty high. You can't see up over them. I don't know if they're playing footsie or what's going on down there. But nonetheless, the government dismisses all statements about GreenField. They say these are vexatious, these are baseless, and these are inappropriate because she's just a civil servant. Are you sick of that? That she's permitted to advise Judge Engoron, just an innocent person, and we're all being mean to her. Yeah. Given the circumstances, this extraordinary position calls into question both the timing of the gag order and the integrity, vel non, of the trial process. Many organizations that GreenField actively supported was supporting the Attorney General. She attended bipartisan events while the case was pending, openly advocated for Joe Biden, commented on the fight against the development of profits of big real estate, talked about the consequences to the former president, Trump, and so on. But the government's perfunctory denomination of this speech as unworthy of this court's consideration, you know, all that stuff, it's like it's her protected free speech. She can do whatever she wants. Well, can Trump comment on that? No, you're not allowed to. Court's consideration fails to overcome the legal infirmities, and the gag order is not valid under the First Amendment. So they say here at the outset, the government attempts to avoid the merits of Trump's claim because they really don't have much to say. There's ample case law and statutory support. It confirms that Trump's challenges to gag orders and Judge Engoron's abuse of contempt power were properly made pursuant to our rules. And the suggestion that Trump's sole recourse for a violation like this is like to wait months or years for a decision on appeal of final judgment is insane. They say this would lead to irreparable injury. Trump's not going to wait until this is over to file his appeal. He's appealing now. He's the front runner. There are collateral consequences here. If we wait 2 years, the election will be over and you'll get your wish. So we don't want that now. We want Trump to be able to speak now, because if he's gagged now, there are harms to his political campaign now. Respondents, they say their sole justification of gag orders, the only thing that the government has to hang their hat on, is unknown third parties and their mean voicemails, that Trump might say something and then they might do something bad. They say this should be rejected. Since before the trial began and continuing thereafter, certain individuals to whom there is no indication that Trump has any connection or any control over these people engages in behavior that they don't condone. And we know that there's some nasty voicemails that were left on some messages. Specifically, an affidavit, there we go, it contains no date or time, and we'll look at this in a different segment, that are reference to the transcribed excerpts, don't know when they came from, and nothing at all except hearsay about any communications to the cell phone or emails. It was blank texts. Now, the affidavit also includes no mention of the fact that on the first day of trial, that the law clerk allowed herself to be voluntarily photographed. She's like, yeah, this is historic, and I get to be a fake judge now. And she identified by the name in the national and international media, despite the existence of purported security concerns. Yeah, she wasn't hiding her face. She was running for office. She's trying to get into the political mix. And standing outside rallies with other, demented people in bars like, this is the election. Moreover, the communications themselves, while vile and reprehensible, and we don't condone any of those communications, but it doesn't mean you get to gag somebody else's speech. They say, like, if it's a threat, the person who said the thing should be prosecuted. Go find them. But those messages do not constitute a clear and present danger of imminent harm as required under the law. A presumptively invalid free speech gag of prior restraint simply cannot be justified after the fact by conflating Trump's valid concerns about their obvious partisan bias with the offensive messages. Just because somebody left you a nasty voicemail doesn't mean that you get to gag me. What? While the comments by anonymous third parties about Engoron's GreenField, his GF, her religion, her Diet Coke, Diet Pepsi consumption, and her personal activities are reprehensible, they are not properly redressed by the gagging of Donald Trump and his First Amendment rights. There is nothing more than this is an endorsement of a heckler's veto if you do that. Now, the purported so-called security concerns are also disingenuous given the law clerk's voluntary public partisan post. And are you kidding me? She's going to write a book about this. She's going to be invited on the Jen Psaki's show, Inside Jen Psaki, and they're going to have all sorts of conversations about this on MSNBC. I'm under attack. It'll probably be the three of them. She'll get Clavicle Girl over there too. She's enjoying this, indulging in this. I'm under attack by the MAGA people. But involved herself in political activities and her insistence in remaining a constant and unprecedented presence on the bench, basically ruling the case, allowing herself to be filmed every day and then viewed by an audience of millions as the extraordinarily high-profile public trial commenced. Now, also, on their face and as applied, the gag orders have prohibited speech about her public and highly partisan political conduct. She did it. Even going so far as to stop the lawyers, okay? Do not do it, Chris, is what the judge said. Denying them from commenting on it in open court, which is wild. You're like, Your Honor, like, I'm literally here for my client to, like, represent my client. Don't do it. You can't file a motion. I have to file. Like, are you crazy? What else do you want me to do? Don't do it, Chris. There is no question that the gag orders proscribe free speech, and they are patently overbroad. Now, the constitutional defects are also compounded by their enforcement. In the two instances of the enforcement to date, Engoron has willfully abused the contempt power. Each time, Engoron, on his own, sua sponte, punished President Trump. He warned that the punishments will increase until Judge Engoron apparently is going to imprison Trump without aiding or abiding by any procedural protection to which Trump is entitled. You go to jail now because I'm the judge. Justice Engoron has likewise confirmed that the gag orders, as applied, stop Trump and their lawyers from even making a record of the conduct or the appearance of bias. Don't even mark it down. Talk about justice dies in darkness, right? You can't even bring it up on the record. Don't even bring it. Thus, the consequences of this court's vacatur of the interim stay are anything but hypothetical. Judge, if you lift this gag, if the court vacates the stay, Engoron is going to continue to dole out the punishment to President Trump and the rest of the petitioners without any process for raising the bench's bias against the petitioners based on the conduct of Engoron. And so we're asking to continue the stay until the petition is decided. Now we'll hit the highlights of the rest of the appeal. You can see the gag orders, they say, should remain stayed. And this is saying that they brought this appeal under the appropriate section of the law. Article 78 is the appropriate petition. We filed it accurately, and we're now working our way up appropriately in front of the Court of Appeals. They say gag orders are reviewable. A lot of this is kind of technical, legal arguments as to why this is the appropriate mechanism. And here they continue. They say the gag orders are also unconstitutional. They try to trivialize Trump's First Amendment rights by dismissing his concerns. They say this is vexatious. We don't understand the First Amendment. We're just dumb prosecutors. We don't get it. But the First Amendment permits comment on public appearance of bias. We're allowed to do this. The gag order brings into sharp relief exactly what speech Engoron is seeking to prevent. When he gagged Trump and his team, It was literally about talking about the law clerk. Now, neither the attorney general nor Engoron, none of them rebut any of Trump's factual claims about her obvious political bias, donating to Democrats, hanging out with Schumer, hanging out with Nadler, supporting Tisch, thousands of dollars to multiple Democrat organizations in violation of the judicial code, and so on. They can't deny that. The evidence is clear. But instead, they just say these are personal attacks made against the court staff. And they summarily dismiss their contents as baseless. Baseless. Do you want to see the spreadsheets? Deranged thug DOJ prosecutors? But this is not the deranged thug DOJ. This is the Luttig crew. So they say baseless too, right? It doesn't matter who you're talking about. They're all interchangeable, really. And you conclude that any personal identifying information is now prohibited. Now, as detailed in the petition, the law clerk made an unsuccessful run, loser, for the Democratic Party nomination in civil court while she was serving as the law clerk. She maintained a public website called GreenField for Civil Court, eventually withdrew, but advised her followers to, quote, keep an eye on this space because I might run again in the future unless I just steal it and insurrect the bench with my sugar judge. Says, posted on the GreenField for Civil Court Instagram, she posted a photograph with Senator Schumer, ultimately reposted by Trump, right? Trump just posted her story that she posted publicly. And he said, you're gagged. Don't you do that. Wait a minute, what? The principal law clerk's public and partisan activity while serving Engoron as her clerk is not cabined to her civil court campaign. The principal law clerk also attended events by the Grand Street Democrats, and they expressed their open disdain for Trump and their open support for Tisch. Now, additionally, after the public records maintained by the Board of Elections reflect that, in 2022, 2023, while the underlying action and a related special proceeding were pending before Judge Engoron, and after the principal law clerk ended her campaign, she was no longer a candidate. She then contributed to Democratic causes and candidates well in excess of the amount permitted under the code. Okay, so she was running and then not running and then making donos, and it was just madness. Now, notably, in a 4-page advisory opinion that was annexed to Trump's unsigned proposed order to show cause, Engoron attempted to address this. Let's see where this goes. But rather than admitting the open and public ethical violation, he justified the violation. He put a cherry-picked, incomplete quote from, this is so crazy, an incomplete quote, just as a judge doing it. Like, a judge is supposed to be like smarter and better and like wiser than everybody else. They said, no, this judge just took a quote out of context, like a law school student. Regarding which is really rude to law school students. I mean, you know, shout out, we all go through it. Regarding the application of the code, the full quotation with the omitted portion emphasized is as follows. Here's the full thing. The $500 limitation on political contributions does not apply to an appointee's contributions to his or her campaign, nor would there be such a monetary restriction on the purchasing of tickets to political functions. Of course, the staff member who becomes a candidate could not contribute to any candidacy other than his or her own. Oops, you left that out. Sorry, Judge. Okay, and just to zoom out on this, so the judicial ethics say this. It's $500, no more. And then they have a judicial ethics opinion, and these are like explanations of the rules. And this is the way that the law works. And that rule is complicated. What does it mean? And then the judicial committee or the state bar or whomever will write the opinion, and it'll explain the rule. And so the judge just said, well, my GreenField can buy tickets to whatever she wants, and that's perfectly legal. And so if she spent $10,000, who cares? Because $9,000 of that was spent for tickets. And you go, what? $9,600 was spent for tickets. She spent like $3,000, if not more, between the 2 years. And that was mostly tickets. So $3,600 or $2,600 was tickets, and the other $400 was the actual donos. Does that make any sense? No, of course not. So the judge just said it was for tickets, and she could deduct that from the total $300. But the rule says, no, you can't do that if you're running for office dono to other candidates, which makes sense because then they would all just be funneling money through each other. judicial ethics opinions. And the judge literally just left it out. It's wild. So now this is a judge, right? This is a judge in a state court. You're supposed to have more ethics than that, but we're dealing with Engoron. Now, it is uncontested that the donations in question were not in support of her own failed campaign, from which she officially withdrew in February 2022, but were in support of other Democrats and their causes. And when he excised the final sentence of the opinion, Engoron deliberately and maliciously ignored the distinction between a candidate donating to her own campaign and donating to another partisan organization. And thus the opinion literally disproves his own conclusions that the donos are proper. The deliberate obfuscation of this fact is troubling, and it's telling of the ethos to defend the principal law clerk and her conduct, regardless of whether it's proper under the law. Right? He's twisting himself and the law into a pretzel to cover up for this woman. And I don't know what she has on him, man. Pictures or videos, more areola photos, more bonus photos. Oh, gosh. So the principal law clerk, her public partisan conduct in violation of ethical rules, which Judge Engoron clearly endorses, along with her prominent role as the co-judge on the bench, has created an untoward appearance of impropriety, suffusing an unprecedented trial of national and international significance. Now, as is evident, it is uncontested and plain to see from press pool photographs that the law clerk has sat on the bench next to the judge this entire trial. She constantly passes him notes, whispers in his ear, and publicly consults with him on nearly every ruling. Counsel has noted this can happen to 30 to 40 times a day. And this extended consultation, and remember, they also moved the cameras around because the media was able to see. Now, this extended consultation occurs primarily when Trump's lawyers, rather than Tishy's lawyers, interpose an objection. Now, while this law clerk, like any judicial appointee, may assist the judge in the discharge of his duties, what we see here is unprecedented. Now, as this court undoubtedly knows, it is not simply not normal or appropriate practice for a law clerk to literally sit on the bench and provide constant input while an elected justice presides. Engoron's emphatic contentions that he is the ultimate decision maker, it's self-serving, it's defensive, and it's untenable, given that everyone in the courtroom that's packed can plainly observe that the parties are arguing the case to both Judge Engoron and to his law clerk. He said, my law clerk doesn't make the rulings, I do. Now, that Judge Engoron feels compelled, right, to repeatedly justify his abnormal practices and to assure the public that he, not his law clerk, is doing his duties, underscores the bizarre and deeply problematic nature of this. There is simply no room in the judicial system for this type of behavior. And by the way, she has heightened her public role to that of a public figure. So stop babying her and telling us she's a public servant. She has put herself in this position. She's going to these roles and wants to sit on the bench. Saying that they publish personally identifying info of her? Give me a break. She created a public Instagram account and posted a picture of her with Schumer. I'm running for office. Vote for me. Neither petitioners nor their lawyers believe that they have an unfettered right to attack a trial. But these circumstances, the clerk's role in the proceeding, her clear partisan activities, warrant commenting on this. And that's our job. Likewise, counsel seeking to comply with their own ethical obligations, we have to vindicate our clients' rights. We must be permitted to create a record. The First Amendment dictates that that speech must be made and must be heard. Now, as we know, prior restraints on speech are presumptively invalid, and concerns about third parties do not justify Engoron's gag. They say Engoron initially proffered without any evidence that we have to protect our staff, so Trump needs to be gagged. Now, as noted, evidence to those threats, he now submits the affirmation. Okay, that just came in. But Mr. Holland avers that on the second day of trial, threats and disparaging comments increased exponentially that were now being directed at the law clerk. And they admit that security concerns existed even before the trial started. Holland, Engoron, and others also failed to note in their little love note that GreenField was also voluntarily photographed. She was videotaped. She was identified by name on the first day of trial before we even started seeing her pass her love notes, before this became a problem. And so Mr. Holland, in the affidavit, in the affirmation, says, yeah, that this has been a problem. We have to constantly reassess what's happening. Now, the bad voicemails are bad, and we don't condone those. But none of those contemptible dross in those voicemails reflected in those messages can be attributed to Trump or his lawyers. They didn't leave them. Nor have President Trump or his counsel ever made a statement about her religion, her Diet Pepsis, or her private activities, other than frolicking with Schumer. Now, rather, the speech prohibited by the gag orders concern about her social media posts that are public, that she talked about in her judicial campaign. And she had the Diet Coke when she was working for Tish. And partisan activity and continued during the pendency of the case. Now, the prohibited speech also concerns her public presence. Also, we can't talk about her campaign contributions. And Trump was given a warning every time it came up. So based upon this abundant public evidence, they say Trump and his lawyers have stated that the law clerk appears to be biased and she exerts an improper influence over the trial. Now, it bears repeating that Trump and his lawyers have never, ever called for violence against her, never condoned it, never encouraged it. But Engoron's misleading contention that conduct that's engaged by petitioners itself consists of that whatever Trump posts on Truth, it causes a deluge of the court's chambers. They say that's false. Despite speculation that Trump's comments resulted in an increase in phone calls, even Mr. Holland confirms Trump has not threatened the GreenField. That such communications, he says, even in his affirmation, they began prior to the commencement of the trial, so there's no causation. They increased in frequency, but it cannot say that Trump and his reposting of the photograph caused it to happen. It might be correlated, but it's not causation. This is particularly true when Engoron has actively encouraged the law clerk to be highly visible. He allowed her to sit there. He allowed photography in the courtroom. The judge did. The judge allowed her to sit up there, and then he kicked him out. Countless press pool photographs literally show him sitting next to her. If the judge didn't want that, he could have kicked the media out. It's his courtroom. By name, it's been republished since the trial began. Now, it is beyond cavil that petitioners are not responsible for this. Now, at the base, the disturbing behavior that was engaged in by anonymous third-party actors towards the judge and the principal law clerk are disturbing. However, it does not justify the wholesale abrogation of Trump's rights. The Constitution does not permit Engoron to stop Trump's speech simply because people react to what Trump says. Indeed, to sustain a gag order, it would be a heckler's veto, and the Constitution has already settled this. You're not allowed to do that. And the cases that the Attorney General cited are garbage, and they're not that bright over there. No support in her position in case law. She improperly invokes these other justifications for invoking these gags, and they are just not sufficient. And it's overbroad, and so the Attorney General should lose. Enforcement of the gag order violated the judiciary law and the rules of the court, and it should be rejected. For the foregoing reasons, Trump requests that this court continue the stay of the gag pending the resolution of this proceeding in the Court of Appeals and any further relief it deems proper. Signed and submitted November 27th here by Alina Alba and Robert Clifford S. Robert over from Robert and Robert PLLC. And so that's landing in the New York State Court of Appeals in the Appellate Division for the First Judicial Department. And the Court of Appeals will continue to assess this case and come to a ruling. We'll see if Judge Engoron's gag order stays. We do know that when there were brief oral arguments in the interim position, when they were considering the administrative interim stay, there were some questions that the Court of Appeals judges had for Engoron and for GreenField. And so, my friends, we're going to be here continuing to cover the New York trial, the RICO trial, the J6 trial, and all of the rest of the Trump trials. I hope you join us as we do. Thanks for taking a moment here to pause and subscribe to our channel. We'd love to see you on the next one. We go live at this time about every day, and we'll look forward to seeing you back here and on the next one. All right, and now let's turn our attention. We're continuing to talk about the theme of the day is kind of gaggy theme, you know, because they're gag-happy people. But let's turn our attention over to January 6th case and Judge Chutkan's order, or Judge Chutkan's forthcoming order. Donald Trump submits his final reply in his motion to dismiss his January 6th case, making the argument that there is no illegal conduct in Jack Smith's indictment. The Constitution protects people under the First Amendment and makes it possible for them to say things that maybe the rest of the government disagrees with. And that's exactly what Trump did. And so we're going to go through this final motion. It's the final word from Trump's team. Remember how this goes. You make a motion to dismiss, and you gotta set a hula hoop. What are the bounds? What are you arguing? And Trump has made several motions to dismiss. Several we've covered here. The motion to dismiss based on statutory construction, saying that the United States Code just doesn't provide any criminal code that Trump can be charged under. We also saw that they filed a motion to dismiss based on vindictive and selective prosecution. People like Molly Gaston, the highlighter girl in the January 6th case, seemingly already had her mind made up before she joined the special counsel's office and wanted Trump basically gone, sending letters to Bill Barr in the aftermath of January 6th, actually in the aftermath of the 2020 election. So a lot of bias, but today we're talking about the constitutional basis for dismissal and why under the Constitution, Trump says, I can't even be prosecuted here. This all needs to go. And this is the final word. So Trump files the motion to dismiss, Jack Smith replies, and Trump issues the response. And this is what it looks like. It's a 25-pager. Filed in the District of Columbia, Judge Chutkan's courtroom. And this is the final word, Trump's reply in support of the motion to dismiss based on constitutional grounds, saying that the First Amendment protects him. Trump's defense writes, all right, Judge Chutkan, this is the final word here. As you know, election advocacy, including petitions to elected officials to redress election-related grievances, complaining about elections that may or may not be rigged, is a fundamental and time-honored tradition in our country. We're allowed to do that. The First Amendment guarantees that the president, just like everyone else, may speak out on the subject and call Congress to action. If we can say the election is rigged and something should be done about it, can Trump? Others are just as free to disagree, and they can urge Congress to take a different course. That's how our country works, and why the Constitution prohibits the state from acting as the, quote, arbiter of truth on matters of public concern. But that's exactly what the prosecution, Jack Smith, and the deranged thugs there think and seek. Rather than conceding, as it must, that election advocacy is, quote, one of the broad areas in which any attempt by the state to penalize the false speech would present a grave and unacceptable danger. Instead, the prosecution seeks to install itself as America's censor. We said the election was victorious for Joe Biden. Shut your mouth. Don't even challenge it at all. Otherwise, we're going to prosecute you for that. With roving authority to criminally prosecute all who speak out against the approved narratives. Now, the prosecution, Jack Smith, Joe Biden, Merrick Garland, they have no such mandate. And accordingly, the indictment is unconstitutional on its face, and it must be dismissed. Now, even if, they argue, even if the First Amendment permitted charges on this basis, which it emphatically does not, President Trump's acquittal before the United States Senate forecloses retrial before this court, as do the Constitution's guarantees of due process and fair notice. So a lot there in that sentence. So first of all, First Amendment under the Constitution says you can challenge the election. You can say it's rigged all day long. You don't get a government conclusion on that. They get to come out and say, nope, it's 100% this is accurate. And if you challenge us, you get charged. That would be crazy, because what could they do next? Well, the global warming is what we say it is. Okay, your new pandemic rules are exactly what we say they are. And if you challenge us, you get prosecuted for that. Right? And that's not what we want in this country. That's kind of insane. But that's also just part one. They also say that under the Constitution, the impeachment and removal process, you can only be criminally charged if you are removed by the Senate. So that is the safeguard against political prosecutions. We have the first trial in the political realm. If we agree that there's overwhelming support that a person actually is impeached, right, and convicted, Then we say, okay, it's clearly not political, kick it outside of the political system, and then let the prosecution start in earnest. But that didn't happen here. Trump was acquitted in the Senate. So they say the First Amendment here bars the prosecution in its entirety. All charges in the indictment, they rest solely on allegations of core political speech and advocacy. Now, you might disagree with Trump. You might say maybe it was a bad executive decision. You might disagree with his discretionary judgment. That's fine. You're free to do that. Doesn't make it a crime. Doesn't make what he did a crime. So hand-waving the First Amendment. They say First Amendment. The prosecution states that President Trump had a right, like every American, to speak publicly about the election and even to claim falsely, true, that there had been outcome determinative fraud during the election and that he won. But they say, but Trump did not stop there. And so they say, okay, wait a minute. So you're saying everything he said is okay? He's allowed to do that? He's allowed to speak publicly about it and even to claim falsely that there was outcome determinative fraud? Okay. But he did not stop there. Okay. So where are we going? So thus, the prosecution then premises its entire case on the notion that Trump did more than supposedly make false claims about the election. But what is that? But what, quote, more? What is the more did President Trump do, according to the prosecution? Let's think. He made more supposedly false claims, about the outcome of election. That's what they said. He's allowed to make false claims, but he made a lot of them. All right. Dozens, they said in the indictment, of specific claims that there had been substantial fraud in certain states and that dead people voted in Georgia. Now, the prosecution says generally that Trump used those lies as instruments of his 4 criminal offenses and that he used those knowingly false statements regarding specific facts to commit the crimes charged in this indictment. But which is amazing that they're going to prove that knowingly. You really think that Trump knew that he lost the election and that was not genuine? But the prosecution, after all we know, but the prosecution does not identify any conduct, no conduct. It's all speech involved in those crimes other than making, in their view, supposedly false statements about the outcome. Thus, the indictment does not allege that he used lies to commit crimes. It alleged that he told lies, and those lies are the crimes. So it's literal speech. Thus, the indictment does not charge speech in furtherance of a crime, okay? It charges speech. That's it. You're not furthering some other crime. The speech itself is the crime. Now, the reason the prosecution does not identify any non-speech or any non-advocacy conduct is because there is none. Every charge in the indictment rests on core acts of political speech and advocacy that lie at the heart of the First Amendment. And likewise, all the factual allegations in the indictment pivot on the indictment's core theory that Trump allegedly engaged in, quote, fraud and, quote, obstruction by repeatedly contending in public and to government officials that the election was tainted by fraud. So, if you're allowed to say the election was rigged and fraudulent once, then it's not illegal, as they admit. It only becomes illegal if you say it a number of times. So if you say it 100 times, is that illegal, or does it need to be 1,000 times? Or is it the thing that you say, and if somebody hears it, then they go do something, you're responsible for that? Does that matter if you say it 1,000 times or one time? That's the heckler's veto, which is nuts. So what's happening here? Now, a comprehensive review of the indictment, says Trump's defense, it reveals that every operative allegation charges Trump with engaging in acts of public speech and political advocacy about the election's outcome. The indictment first alleges that Trump made a long series of public statements about matters of enormous public concern, criticizing the administration of the 2020 election, claiming fraud and other irregularities tainted the outcome in particular states, and making claims about the scope of the vice president's constitutional authority. All speech. These public statements were posted on Twitter, and all these allegations are on the prosecution's core theory that Trump supposedly spread lies that there had been outcome determinative fraud and that he had actually won. So that's all speech. He made claims about fraud. Second, the indictment alleges that Trump made statements to DOJ officials. He said to them, fraud, irregularities, tainted the outcome of the election. Again, every allegation says that Trump supposedly falsely urged federal officials that there was significant fraud in the election. Speech, and he's free to do that. He's the president. Third, the indictment alleges a series of communications to state officials claiming fraud there. Again, all these are supposedly false statements, was on the basis that there was significant fraud in the administration of their election. And fourth, the indictment alleges a series of communications with Vice President Pence and similar attempts with other members of Congress and so on. And fifth, the indictment says that Trump was organizing alternate electors. And once again, the basis for organizing this was asserting that the view that the actual electors were invalid because the states had been tainted by fraud or irregularity, right? So in other words, you put up 2 slates of electors. If you determine that there is fraud, you have a backup plan, right? You have a placeholder, and that's just standard business. Has been in every election. So thus, every allegation in the indictment, when they summarize them all, including all the accounts charged, center on a theory that Trump committed a fraud or an obstruction by repeatedly contending that there had been fraud in the election. But Trump's defense says, nope. In short, despite acknowledging from the government's own words that every defendant has a right to speak about this, they then present these statements as the only material acts of wrongdoing. Thus, this case is not about what Trump did at all. It's about what he said. Trump's motion explained in detail that claims about fraud are protected speech. Supreme Court had unanimous consensus that the government may not criminalize supposedly false statements about philosophy, religion, history, the social sciences, the arts, other matters of public concern. It's just criminal now to have an opinion? Alito said that's perilous. You can't let the state become the arbiter of truth. Otherwise, the potential for abuse of power is simply too great. In this political arena, when disputes arise that are not easily verifiable, the threat of criminal prosecution is particularly dangerous. Our constitutional tradition stands against the idea that we need Oceana's Ministry of Truth from Orwell's 1984. But even Jack Smith and the deranged thugs over there, they don't meaningfully even dispute this point. Instead, Jack Smith, and they contend that Trump made not just general assertions, but he made concrete, specific statements about specific acts of fraud, and that those render his speech criminal. So you're too specific. Your speech is too accurate. The prosecution cites no authority for this supposed so-called specificity exemption. You're too accurate. You can't talk about the facts. None exists. Claims of matters of public concern are protected. Now, the prosecution conveniently omits that phrase, but they're all protected. This idea of a specificity exception also runs afoul of Supreme Court precedent. That case says you're not allowed to do it. And the speech and this other exception also does not apply. And they give us some good case law there that we'll fast forward through. Now, they say their attempt to distinguish these cases falls flat. But instead, the First Amendment and the problems with the government's new, novel, and unprecedented theory of criminal liability, it goes beyond the indictment. But it also goes to the underlying criminal statutes that are charged in this case. So it's not only how Jack Smith is using the law, but it's the law. If the prosecution is correct, and those statutes that they think apply to Trump, if they do criminalize core political speech as charged, well, then those statutes are facially unconstitutional. So if you think that you can apply those to Trump's speech, well, then those statutes are unconstitutional, if that's accurate. Or the more reasonable interpretation is that those statutes don't apply to speech. Any statute that criminalizes core political speech is invalid, at least as applied where the criminalization of protected speech is, quote, not only real, but substantial as well, judged in relation to the statute's plainly legitimate sweep. So you can have some law that might incidentally criminalize some speech, but if it does as a primary, charge, that's patently unconstitutional is what they say. Now, as discussed above, the prosecution's interpretation of these statutes entails that they criminalize a wide range of perfectly ordinary public speech and petitioning the government and the prosecution therefore renders its own statutes invalid by seeking to extend them to Trump's speech. So if you're saying that's how you interpret the rules have to be invalid. And a quick comment on, we've seen some points here that Alito has been dissenting. And this comes from a case where I don't think that there was a majority opinion. So there was a concurring opinion, and that's why they use the phrase consensus opinion. So basically they're cobbling together from a case where there's no consensus on this, a consensus. On this issue that we're seeing right now, they're using another case to say there was a concurring opinion, there was a dissenting opinion, and from that, you can glean out a consensus interpretation to the Supreme Court and what they're doing. So that's why you're seeing some of that being used here. Now, at some point, we'll see if this gets settled by the Supreme Court and we'll have a majority opinion one way or the other. But carrying on, they say, in addition to Trump and his speech being protected under the First Amendment, we also have due process problems. Double jeopardy problems. You can't be prosecuted for the same crime twice. They say that the impeachment clause, the text and the history support prosecution here. Remember that Trump's people say that you have to be convicted in the Senate first. The prosecution is block quoting the clause. On their view, the phrase party convicted actually means that both the party convicted and the party acquitted. So the party convicted, they say, it means either of the things, which is weird. And it also means a party who was never impeached at all. And so, yeah, obviously, as a matter of plain meaning, their interpretation makes no sense, obviously, because they're not that bright over there. Now, obviously, an acquittal by the Senate is more likely than a Senate conviction to foreclose future prosecution. So if Trump would have been convicted in the Senate, which he was not, then he could have been prosecuted outside of the political process. Thus, if the framers had wished to clarify that impeachment and the trial in the Senate would have no impact on future prosecution, regardless of the outcome, one would have expected them to state that, quote, the party impeached shall nevertheless be liable and subject to the indictment. But they didn't. They said the party convicted, because you get impeached in the House and then you go to the Senate for the trial. So the party impeached would mean that if you just got impeached in the House, that you could be subject to criminal prosecution. But convicted means no. You got to go to the Senate, and Trump was not convicted either time. So proving this point, if the framers wanted to specify that only the party convicted could be prosecuted and not the party acquitted, the actual phrasing of the clause is the most ordinary and natural way to do so. Totally agree. That seems obvious. The plain implication means you got to be convicted in the Senate, but they're not going to try to do that. And they're going to give us some background here. Hamilton talked about it in Federalist number 68, 65, other historical interpretations of this as well. The historical sources do not undermine the consensus. They're pulling some other stuff in from the Federalist Papers in Madison and elsewhere. Representative Dana in 1798 and so on. But they say here, the impeachment clause, it's rooted in the political process, and it just makes sense from the structure. It says it makes policy arguments that they don't cite any original sources. They're drawn from OLC, Office of Legal Counsel opinions. And here, in each case, the prosecution argues as a policy matter that criminal prosecutions should be treated as independent from impeachment and Senate, because the Senate trial might not result in the acquittal of a president whose political enemies deem him guilty. So they're saying actually the judicial process is safer than the Senate process. But they say, nope, sorry, this argument flips the Constitution and its structure on its head. The impeachment judgment clause and all the related impeachment clauses provide the president with critical structural protections from attacks from his political enemies. That's why we have it. Now, the requirements of impeachment by the House and the conviction by 2/3 of the Senate ensure that he cannot be removed and then subsequently prosecuted without widespread political consensus to get there. The fact that partisan loyalties or popular sentiment might influence the Senate's decision is a feature. It's not a bug. We want it to reach a critical mass before we cross that threshold. This is why we talk about political checks and balances, and the Supreme Court has supported that as well. James Madison reinforced this structure, Federalist 47. He said he cautioned against newfangled and artificial treasons, which have been the great engines by which violent factions and the natural offspring of free governments have wreaked their alternate malignity on each other. So don't allow all sorts of weaponized political attacks to exist in your country. Now, the Democrats have shattered that. And now we've got 234 years of precedent gone. They talk about the double jeopardy clause and why it's consistent to not have two trials, a political trial and then a criminal trial. It is being prosecuted for the same crime twice, which is what they're trying to do here. So that's the next big section. Trump and the process is invalid because the Senate needed to have convicted him in order for this to carry over to the next stage. And then lastly, the final big section, President Trump did not have fair notice that the political speech is a crime. If those statutes are in fact allowed to criminalize speech, then they're invalid. And Trump had no notice that his speech could be criminalized, which means the laws are invalid. President Trump addresses this argument about whether he had fair notice about the crimes. Now, he explains that more in a different motion, which we'll cover later this week. But he says, as argued in Trump's motion to dismiss on constitutional grounds, these fair notice problems afflict the entire indictment, and the court should dismiss this in full. And the principal reason is on page 1 of the government's brief, their own brief. They say, as they proclaim, President Trump stands alone in American history for his alleged crimes. Stands alone in American history for his alleged crimes. Yeah, nobody else ever has been charged or even knew that you could be charged. We got like 20 minutes of Democrats saying, fight like heck. We're going to get out there, get in their faces, fight, fight, fight all over the place. That admits the novelty of their criminal theories. They just made it up. And such unprecedented novelty is antithetical to the constitutional requirements of fair notice. The first time ever. Now, the prosecution does not dispute that there have been many challenges to the counting of electoral votes and 0 federal prosecutions or even suggestions that such challenges are criminal. You guys ever prosecuted anybody else for this before? No. That the charged conduct is the same category as those historical examples indicates that no one really reasonably understood the conduct. Instead, the prosecution flips the analysis on their head. They say that the absence of prior prosecutions is not equivalent to treating this as non-criminal. But the test is not whether a court said that Trump's conduct was not criminal. The test is whether a court clearly said that it was criminal. Because you need to have notice of this thing. And it's the prosecution's burden to show that. They have not done that. The most specific argument that they have is this point, but as they're going to show in another motion, it is meritless. To be clear, they say that the prosecution's discussion of the Electoral College also misses the point and attempts to distinguish the other elections fall flat. The prosecution misses the relevance of the Electoral College contest in 2016. And they say all we need to do here is apply the facts, and it's not any sort of novel judicial construction. But that's not true. They say it provides a regular course of practice. Here, the statutes do not plainly cover the conduct alleged in the indictment, and so it cannot stand. Therefore, the indictment, says Trump's defense, should be dismissed with prejudice and not come back. Sincerely signed by Todd Blanche and John Lauro, 2 Trump defense attorneys. And this is the final word on this one. So this will be off to Judge Chutkan's desk for a ruling. And of course, I think that she's going to respond with a big denied. So we'll see a big denied on this one. And we'll see what Trump does as a result of that, whether he appeals this on interlocutory grounds, saying that the consequence of not dismissing this impacts the election and that this should be decided now by the Supreme Court. We need to know, does the First Amendment allow the criminalization of electoral challenges? Does the lack of notice, nobody's ever been prosecuted for this before, does that violate due process? Can you be prosecuted twice for the same crime, once in the Senate and acquitted, and then charged again? Jack Smith and Joe Biden, Merrick Garland, they say yes. But Trump is saying no. We'll see what Judge Chutkan says. And then, of course, we will carry this into the conclusion. We're covering all the Trump trials here. D.C., New York, Georgia, Florida, all of them. And so we hope you join us as we continue to cover it so that we can unpack all this madness together. We'll look forward to seeing you on the next one. All right, my friends. And now we got one final segment on the day. We got some MSNBC clips. All right, so, prepare yourself. But this is the final wrap up, and this is Trump's response. Donald Trump blasts Judge Engoron's law clerk. We know that the gag order is still in a stayed position. So Trump has a little bit of his free speech back now. That's very nice of them. But he used it pretty effectively. Over the holiday break, he posted on the Truth platform, saying a bunch about Allison GreenField, Psycho Engoron, Peekaboo James, and others. And what happened right after that, or around the same time, is Jack Smith notified the Court of Appeals. The gag order is pending in the New York Court of Appeals. And he says, see, this is why we need the gag, is because Trump is posting mean things on the Truth platform. So we'll read through that. Trump's attorneys responded to Jack Smith's little tattletale. And then we have MSNBC that kind of, hit the hyperventilation button over there with what might be one of the key witnesses in the January 6th case, maybe as an expert witness or somebody, we'll see. But he was called to the January 6th Select Committee hearings, Judge Luttig. We'll hear from him and two other people who say, okay, people are not getting it. Trump is a monster. Why aren't voters recognizing what a danger he is? And so we're going to go through all of it. But first, this is Trump's post on the True Social, and it was a burner. And I think this is what we should be hearing from him, because he is criticizing people who lack credibility, who are partisan and biased, and who are attacking not only him, but his organization and everybody else who works for them in New York. So he posted this, November 23rd, 12:03 a.m. Trump says, "Happy Thanksgiving to all, including the racist and incompetent Attorney General of New York State, Letitia Peekaboo James, who has let murder and violent crime flourish and businesses flee. The radical left Trump-hating judge, a psycho, Arthur Engoron, who criminally defrauded the state of New York and me by purposely valuing my assets at a tiny fraction of what they are really worth in order to convict me of fraud before even a trial or seeing any proof, and used his politically biased and corrupt campaign finance violator, for those donos, Chief Clerk Allison GreenField, to sit by his side on the bench and tell him what to do, and crooked Joe Biden, who has weaponized his Department of Injustice against his political opponent and allowed our country to go to hell, and all of the other radical left lunatics, communists, fascists, Marxists, Democrats, and rhinos who are seriously looking to destroy our country. Have no fear, however. We will win the presidential election of 2024 and make America great again." November 23rd, 12:03 a.m., Trump drops the truth. Now, what we see right after that is Jack Smith has a little bit of a fit. I can't believe he's talking about Allison GreenField. Oh, we need the gag. And so this is what he says from the special counsel's office. This is Jack Smith's office from the U.S. Department of Justice. This is to the different Court of Appeals. This is to the District of Columbia, the D.C. Circuit. So we've got a lot of gag appeals going on right now. Engoron's gag appeal is in the New York Court of Appeals. This one, which is a state court, this is in the Federal Court of Appeals for the District of Columbia. And this is a letter from the U.S. Attorney, Assistant Special Counsel, Cecil Van Devender. He says, Court of Appeals, the government submits this letter pursuant to the rules to notify the Court of Appeals of a document that was filed on November 22nd in connection with an appeal in Engoron's courtroom, which was referenced in the party's briefing and arises out of an incident that the district court discussed at the October hearing. And specifically, the government refers to the Court of Appeals in the federal case to Exhibit E. in the attached affidavit, which is a sworn affirmation by an employee of the New York court system assigned to the Threats Assessment Unit discussing Trump's social media post, which resulted in, quote, hundreds of threatening and harassing voicemail messages that have been transcribed in over 275 single-spaced pages. Now, because the parties referenced in the matter in their briefs and the court inquired an oral argument about evidence of ongoing threats and harassment, we respectfully submit Exhibit E and the related documents for completeness as a supplemental authority. Signed by government bureaucrat for Jack Smith's office, Cecil Van de Vender. And this is their affirmation in opposition. They're saying, this is deputy counsel and David Nocenti. And so there's a bunch of different attachments here. But let's fast forward to Exhibit E. That she said, hey, look at Exhibit E. We're very concerned about Exhibit E. And this is the affirmation from Charles Holland. And we've talked about this in previous segments, but they keep using this, right? And this was also the one in Trump's Court of Appeal, in the New York appeal. He also said, this is very curious because all these voicemails, as we'll see here, this one came to Judge Engoron's voicemail. I'm not going to call you. I'm not going to call you too many names, Judge. Today, it's clear you're a little something. You like to do things, and I'm sure. And your shirtless pictures is very inappropriate. You're so inappropriate, but you're clearly a dork. Everything about you screams like a dork. So again, I hope they, and things. Then it gets into, there's probably some criminal elements to this. Right? It gets pretty, complicated in terms of the law, but you can read it. But the point is, when was this said? When was this said? We have all of these quotes, okay? You're terrible. Date and time? Don't know. Date and time? Don't know. Date and time? Don't know. These are all for Allison, so-called. And so they're bad messages, but if they are actual harassment, guess what? That's a crime. You can charge that. Go charge them for a crime under New York law. You have their voicemails? Great. You have the phone numbers? Great. Can your New York Police Department backtrace that? Yes, they can. Great. Go find them and arrest them. Threatening phone calls. Same thing there. Okay. If it's an actual threat, that's a crime. You can go prosecute those people. So they're free to do that. But we don't even know, first of all, that they came from Trump because we don't have a date and time. And it sounds like a lot of this stuff, right? If you just read through them, it's hard to even see that they're responding to Trump. Trump told me to call you and take you out or something. No, they sound like just unwell people. Okay. And in a big country, a law of big numbers, this is something that happens, unfortunately. And this is something that happens in all cases. Do you think that the clerks did not get phone calls about Johnny Depp or whatever her name was, whatever that case was? Okay. It happens all the time in many cases. And these people should be used to dealing with some very, very difficult people like cartel members or something, right? Organized crime. These are some nasty phone calls and voicemails. But of course, Jack Smith is notifying the Court of Appeals. See what's going to happen to all of us if you don't gag Trump? Well, Trump and his team responded. This is what it looks like. They said, all right, listen, Court of Appeals. Here, this is from James Otis Law Group. He sends this over. He says, all right, this is a response to their little tattletale letter. He says, the prosecution letter, they cite a submission, which is a completely separate case to the New York Appellate Division. And they say that we now have, quote, new information. What? But that new information that's new, it goes back to October 3rd, 2 weeks before the gag order in this case, in Chutkan's case, was even entered. The letter is an impermissible attempt to supplement the record on appeal with irrelevant information that could have been, but was not, submitted into the district court below. So they don't get to add it in now. Now, to date, Trump's defense says the prosecution has never submitted any evidence of alleged threats or harassment to any prosecutor, court staffer, or potential witness in this case. Stop the domino effect. This falls short of the standard under federal court for the solidity of evidence required to justify a prior restraint. So it's nice that you have those little voicemail memos, but no thanks. Moreover, the cited affirmation, albeit irrelevant, concedes that Mr. Trump, they said it in there, did not directly threaten Ms. GreenField. Instead, it describes the speech by unidentified, independent third parties. Now, this confirms, and I'm sure if they looked it up, they could go find those people. Now, this confirms that the prosecution, go have the FBI look into it. Okay, they'll drop everything and go find them. Now, this confirms that the prosecution seeks to impose a speech burden based on audience reactions. Which is simply government hostility, and you can't have that. Now, the prosecution also ignores that the trial judge and the principal law clerk are both judicial officers, and the principal law clerk violated New York law by engaging in partisan activity that's forbidden while the case was pending. And of course, the operation of the courts and the judicial conduct of judges are matters of utmost public concern. So we're allowed to talk about it. It says the special counsel, instead, has brought an inflammatory, lawless indictment, has made false and misleading statements about President Trump, and has leaked confidential information in order to harm President Trump. Both the indictment and the gag order represent an unconstitutional attempt to silence him, and they are clearly election interference. The constitutional guarantee has its fullest and most urgent application precisely to the conduct of campaigns for political office, respectfully submitted to the D.C. Circuit Court of Appeals, challenging the Chutkan gag order or notifying them on the Chutkan gag order, responding to Jack Smith's little tattletale letter. And you can see signed here by John Sauer on behalf of Donald Trump. And so we'll see where this ultimately goes. We're expecting a ruling, hopefully any day now, on this to see if portions of the gag order are stayed or what the Court of Appeals does. But a lot of people were concerned about this. Oh my gosh, Donald Trump attacked the judge's law clerk over the weekend. In fact, this is what ABC said when they were having a roundtable about this. Can you believe what Trump is doing? Here is what they sounded like.
Speaking of mental state, I assume you guys all saw the Thanksgiving message that Donald Trump put out. So he put out a post on Truth Social at 2:03 a.m. on Thanksgiving that was this long screed against all the people that he hates. but he went specifically at the judge in the New York civil case and the clerk. The clerk, who has faced a barrage of threats on her personal phone, threats, anti-Semitic threats. I mean, what do you make of that?
Donald Trump is seeking perhaps to taunt these judges to, not only have a gag order, but to seek some enforcement against himself. If his campaign is built on revenge and retribution, he wants to be ever more the victim. But the problem right now is that
you guys prosecuted him 4 times. What are you talking about? He's making himself the victim. You think he wants to be he wanted to go down this route? You started it.
Voters seem to have stopped processing just how out of control Donald Trump is. It's not just that he's prone to misstatements and gaffes that he taunts Joe Biden for, but to call him unhinged suggests that he was hinged. But, this is really, it's a remarkable moment where he's rising in the polls, to Sarah's point. And yet,
they're shaking.
Here we are.
And this is as there are court proceedings on a gag order.
I was just going to say that the federal one is pending in the D.C. Circuit. We just heard arguments in that recently. There's huge problems with that gag order. The last time we saw a similar gag order against a political candidate back in the 80s against Harold Ford Sr., that was significantly struck down. The Supreme Court's never ruled on a gag order before. They've never even said it's constitutional. And so in the meantime, you have Donald Trump clearly wanting to test the limits of that. The First Amendment, a political candidate, the core of our free speech rights, versus a criminal proceeding in D.C. Of course, the New York one's a civil proceeding. I think you're exactly right. If, you want to win over the judge, at the point that you haven't won over the judge, you want to annoy the judge enough to make reversible error so that you can go up on appeal. And in the political case, all the better. Have them enforce that gag order if you're the Trump campaign. It will only make him bigger news.
Ooh, I think you might be right about that. So every time they try to box him in, people recognize that they are not legitimate. And it feels like they are attacking their political opponents because they are. We can all see it. Now they want to tell us like it's the DOJ and they're a legitimate institution and you should not attack them. And that is exactly the opposite of the First Amendment. And so this is one of the more unintelligent judges that is here. This is Judge Luttig. He was somebody who testified in front of the January 6th Select Committee with Liz Cheney. We'll see how much we can tolerate. he might be a witness in the January 6th case with Judge Chutkan.
In recent weeks, the former president has virulently escalated his contemptuous rhetorical attacks on the institutions of law and democracy in our country.
You're allowed to do that.
The purpose and the intent of these attacks is to delegitimize these institutions in the eyes of the American people.
Well, if they are illegitimate, if they are lacking credibility, then we deserve to talk about that, and we deserve to have a challenge to them. Right? If you're being, if the power structure is corrupted, the only thing you can do is speak out about that, so that you can rally people to your cause, so that you can get enough votes to change the power structure. That's the whole point. And so Trump would never sit around and just say the DOJ is legitimate. And just flip this around, by the way. If Donald Trump was prosecuting Joe Biden or Barack Obama or Hillary Clinton in some courtroom in Texas, and the judge's clerk was, you know, hanging out with Ken Paxton or something like that, right? Or whatever, they would freak out about that. And it would also be illegitimate. This is why you don't prosecute your political opponents, right? This is why you don't go down that route, so that you don't have to have these battles, unless it's really clear, unless it's unequivocal. But it's not in this case. In fact, it is pretty equivocal. They've indicted him 4 times, and the American people don't buy it.
In anticipation of his campaign for the presidency as the Republican nominee, but also to serve his own purposes as he faces criminal trials in multiple jurisdictions. The former president, unfortunately, has largely succeeded in doing exactly that over the past few years.
That's right. But it's not, Trump is very persuasive, no doubt about that. But he doesn't need to do much. Okay, they're doing it on their own, and we've watched it. They indicted him for documents. What? And Joe Biden's not getting indicted? There's cocaine at the White House, and Donald Trump is getting indicted for January 6th? What? They're going after his businesses. Miss Bergdorf, they created a statute in New York to allow adult survivors to bring in new claims. And now that's backfiring. Now you're getting a bunch of other celebrities in New York getting hit. So it's a nonstop, lawfare, and people don't like that. We can see clearly on its face, there's no credibility there. And so they're doing it to themselves, which is the point we've been making for years. They're doing it to themselves. Like, these people don't even know what they're contending with. They are focused on raw political power, but they are exercising that power in such a reckless manner that they are actually evaporating their own power. The reason the Justice Department works, the reason the Supreme Court works, is because people believe that they're legitimate. People believe that they're credible. And when that goes away, everything breaks down. You can indict somebody 4 times, nobody blinks an eye.
He's delegitimized in the eyes of the American people the institutions of law and democracy.
You guys did it to yourselves.
Millions of Americans today no longer believe in their democracy, their elections, and their institutions of democracy and law. Today, we see the former president is viciously attacking the federal courts and even the individual judges who will preside over his cases in an effort to delegitimize the federal courts and the state courts,
you're allowed to comment
and the judges who hold office in the judiciaries. The prohibitively high cost to the nation at this point, though, is that over the past 3 years, if not longer, the former president has normalized his behavior and his delegitimizing and dehumanizing rhetoric into our political culture, where it will stay forever.
Yeah, they've created this. I mean, they're the ones who broke glass in case of emergency. They decided 234 years of historical precedent not worth really adhering to. And so they decided, let's go ahead and prosecute our political opponents. And then they're screaming at Trump. How dare he attack our institutions? How dare he defend himself against judges who have a history of being partisan, who put, their highlight reel in their newsletters, and who will also file documents. There it is. also pull up statements in sentencings like Judge Chutkan saying that Trump should be prosecuted before the case was even filed. So many of these people are biased. Molly Gaston, other prosecutors have gone, were already involved in Trump investigations well before they made their way to the special counsel's office. And they are just organizing themselves to take out their opponent.
We're now a few hours out. How do you think these judges are going to rule tomorrow?
I think the judges will decide to uphold the gag order. If Trump had shown that he had the ability to constrain his behavior, perhaps they would have considered whether the measure was necessary. But since he continues to double down and as you say, Alicia, inflict this sort of damage not just on individuals involved in the system, but in the system itself, I think it's very likely that we'll see the gag order sustained.
Okay, so
it will be she says it will be a Trump-specific gag order. So Trump himself is such a monster that free speech is important, but not that important. Okay, Trump has really broken the level of what we can allow in this process.
I always like to remind our viewers, though our viewers are smart and do not need the reminder, that we're talking about multiple gag orders here. So that's the New York civil fraud trial. We also have Trump's federal gag order. You actually had the chance to listen in on those arguments. Your big takeaways?
Well, look, I think here, too, the gag order is necessary. In fact, Jack Smith filed on Thanksgiving Day a notice with the court alerting them to what was going on in New York and to this 275 pages of complaints, of emails, of phone calls that the clerk in New York had received. Wow. And they documented how the threats rose when Trump posted. I think this is compelling in Washington. And here is the problem. No court wants to be the court that permits an attack to occur, whether it's on a witness or juror or court personnel, because they didn't take steps in advance that could have kept Trump from continuing to post.
Thugs that are being orchestrated by Joe Biden and Merrick Garland, he's got to be gagged. Otherwise, he can speak too much truth and people might hear it and they might realize what's reality and what's not. So, of course, my friends, we're covering all the Trump trials here. I'd love it if you subscribed, wherever it is you're watching this, joining us to come here. We go live at 5 p.m. Eastern time, all the weekdays. We'd love it if you joined us. Thanks for also inviting a friend or family member to come check out our channel so that they can see the inner workings behind all of these cases, what's actually being filed, and we'll look forward to seeing you and them back here on the next one. All right, my friends. Well, we covered some good ground today. It's a beautiful Monday. It's great to be back here with you. I hope you had a beautiful holiday. And again, apologies to our Rumble friends. I don't know what was happening with the video today, so we're going to upload everything. And it looks like that stream never ultimately connected, of course. So, all right. So we covered some good ground. We got Trump blasting Engoron's staff while the gag order is in an interim stay. We also got Trump and his motion to dismiss based on constitutional grounds. We know Allison GreenField, the judge's GF, busted in new videos and photos. And of course, now, my friends, it's time to hear from you. We are going to go over to watchingthewatchers.locals.com for our members only after party as soon as we're done here after the program's over here. But first, let's hear from you and see what you have to say about this. Some very nice, very generous donos came in. We also got some new supporters in our community. First one in the house, and thank you to Donut Mind Me, who is clipping away for us. Shout out to Donut. Who's joining us here? We got one in the house as a new supporter. Blue Sky is now a new member over on the YouTubes. Welcome aboard, Blue Sky. Nice to have you. And upgraded your membership too. Ooh, Blue Sky upgraded Membo to the shout out support. Good to see you there, Blue Sky. Thanks for joining us on the tubes. We've also got Vardolino over on the locals. Looks like a new name. Welcome, Vardolino. Thanks for jumping in, and thanks for saying what's up in the chat. Says, can the J6 persecution victims start a class action lawsuit against the DC government or against corrupt individuals like Nancy? Unfortunately, the short answer is no on that. You know, Vardolino. I mean, the easy answer is like, yes, they could sue, but is it going to go anywhere? The answer is largely going to be no. The reason why is these types of questions will fall into what's called a political question. It's a standing problem. So just like you can't sue somebody if like there's no, you know, if the issue's moot, like if it's not ripe enough yet, right? If the issue's moot or not ripe, or if it's, not the right party. But if it's a political question, they just say, go vote. If you don't like what our government did to the J6 victims, go vote. You know, that's the answer. It's not a very satisfying answer, but, or run, you know, or run for office, one of the two. But if it's a political question, they say the courts are not the best forum for dealing with those. The political process is. So that's kind of the general answer. Ray K says, was busy in Australia for 5 weeks, man. Missed you, Rob. Ray K, we missed you too. And a membo for 21 months. Oh my goodness. We're almost at our 2-year anniversary. And that, I don't even know how many babies that is. That's definitely 2 babies. And then I think it comes up, yeah, we're getting close on 3 babies, man. We're getting close to 3 babies, Ray K. That's amazing. Thank you for being a membo for 21 months, for being so amazing. Hopefully you had a great time in Australia. I was watching an Australia spider video the other day. They got some big spiders over there. Gina Regina is in the house, been a member for 2 months. First month's the hardest. Second month, it gets easier from there. Nice to see you, Gina. Says, I hope everyone had a wonderful holiday. You too, Gina. And look at that real good boy right there in that photo. Real handsome. And of course, Gina Regina, very nice to see you. I hope you had a wonderful holiday. You too, Gina. Thanks for being a membo. Rick Bing is joining us and bringing in 5 new membos in the house. Rick Bing. And hey, you two membos, don't forget to grab the Telegram link. So go over to the channel tab, navigate down to the community section. There are posts there. Scroll down. You'll see Telegram. Grab the link. We'll see you over there for membos. Rick Bing is bringing in No Jabsky, Michael K, James H, Dog B, and another person coming in courtesy of Rick B. Rick, thank you so much for bringing in membos, and thanks for being a membo and supporting our work here. We also got Knox Bierman says, sorry, she's a whale and she should stop wearing clingy fabric. Knox said it, not me. But yeah, the Diet Cokes, the Diet Pepsis, definitely not working. Definitely not working. A change up is in order. We got this one from Puck Roger. What's up, Puck? Bringing in a new pair. Looks like he says cool with a nice little glass. Cool to you, Puck Roger. Thank you for the dono. And thanks for submitting a super chat. Your very first one on our channel. Beautiful. Love it. We got another one from Knox. Says, I missed everyone. Hope it was a great holiday for all. I ended up in the jumping castle with a bunch of grandbabies. Oh my gosh, Knox. You sound like you've got some good energy. I mean, a bouncy castle, man. I think I'd like throw out my back if I was in a bouncy castle. Man, so good for you for getting in there. A bunch of grandbabies. It was a great holiday. I had 2 lovely Thanksgivings. I was up north and then down south. And it was just beautiful. Got to see some amazing people and spend some good time with people that I love. So it was great. Thank you, Knox. And hopefully the grandbabies are doing good and you're doing good. B. Torn is here, says it is time that political party affiliations are protected from discrimination, just like the 60s Civil Rights Act protected a slew of other much needed identifiers were. Well, I don't know. I mean, then I think we'd see a bunch of litigation around that, right? You'd see like a bunch of Democrats saying like, I'm being prosecuted, I'm being victimized by right-wingers. It'd open up a whole new can of worms, but it's an interesting comment there, B. Torn, and I appreciate the dono on that. You know, a lot of litigation, I think, is being exploited, and a lot of laws are being exploited, and, you know, it's pretty messy out there. But good to see you, B. Torn. Thanks for sending that one in. Dolphin Fan is the man, bringing in 5 new membos in the house. We got Luke is coming in. Lovely Uni's here. Charmaine Lily, a job well done, a job done well. And the Sentinel, all coming in courtesy of Dolphin Fan is the man, bringing in 5 new membos in the house. And hey, we got MT Coiner is joining us. What's up, MT Coiner? Been a membo for 3 months. And I told him, man, the first month's the hardest. If you can make it past month 2, month 3, it's easy it's easy going for there. So thank you, MT Coiner, for being a membo. Thanks for the coverage, and I love you back, brother. Thanks for that. Zulu has been a member for 21 months as well. Another 21-monther anniversary. And that Zulu did the math for us on this one. It's 2.3333 indefinite. What's the word? Repeating. Man, that's the math phrase. 2.3 repeating babies. Zulu, thanks for being a member, man, for 21 months. 2 1/3 babies. It's a lot. It's a lot. We got a whole household running around. So thank you, Zulu. Thanks for modding down the fort for us too, my man. Appreciate that. We got this one from Facts Matter. Says Zulu has 3 Saki babies. Oh, man. I think Zulu might be happy about that. You know, Zulu might be little Zulu sake babies running around in the household. I'm sure it's fun. Zulu would probably be thrilled. All right, happy birthday to the babies at the Zulu household. We got Glenn Croy is bringing in 5 new membos. Dark and Snyder's coming in. Fresio. We got Kevin H. We got Andrew D. We got Philip H. All in the house, courtesy of Glenn Croy. Yeah. Oh yeah. Zach says we're almost at pi. How many babies do you need for a pi? For pi 3.14157, something like that. How many months is that? I don't know. You have to do the math on that one. Tom is here. What's up, Tom? McSee says, I just watched 2000 Mules the other day. Funny how FBI used their data to arrest 2 gang members they think were involved in a shooting and a bunch of J6ers, but the MSM says the data is unreliable when it comes to voter fraud. From Tom McSee. Good comment. Well, it's only unreliable for them in the context of our analysis. But I think they know what's really going on. Tom McSee says, they're not only going after Trump, they apparently want to destroy or at least minimize the office as well. Meaning the office of the presidency? But that, yeah, maybe. I mean, maybe if they want to get control. I think they just want puppets in control of things. And it doesn't really matter who it is. Like Joe Biden is obviously not in control of the country. So, whoever's pulling his strings, Obama or whoever. Yo-Hey Plummin says, how many of those calls were made by Democrats? How many of those calls were made by Democrats? Been a membo for 1 month. First month's the hardest, Yo-Hey. We'll hopefully see you next month. So it's a good question. I don't know. Good question. Or just very sick, unwell people left voicemails. Like they're not legitimate. They're not hearing Trump. They're not on social media. They just are not well. We've got Knox says, and are all these MSN people reading Truth Social? I'm never on it personally, and certainly not at 2:03 a.m. Yeah, so it's 12:03 my time, so that's 2:03 their time. Probably. I mean, they're Trump deranged, man. They're like, it's their whole show. It's like their show prep. What are we going to talk about today? I don't know. What's Trump doing? I don't know. Pull up his truth. Oh my gosh, I'm offended. There's the show. There's the whole show. Great. Don't even have to do anything. Don't even need writers. Just react to Trump. All right. We also got, what's up, Knox? We got Voice says, these cases show me we need more than appellate courts to address judges that show bias in cases. To see what's happening behind the scenes is disgraceful. Chauvin and these cases are examples of why. Yeah, and again, it's like, I think some of that goes back to legitimacy. It's like the courts don't want to step in stuff like that. They don't want to just get involved. Like the Supreme Court doesn't want to get involved with Chauvin. It's like, that just happened. The people of the jurisdiction decided, and nothing for us to unpack there. And yeah, it's not good, right? You get some very bad outcomes, and Chauvin's a bad example of that, a good example of a bad outcome. Robin Mays is a supporter. Great to see you, Robin Mays. Welcome to our amazing community. Love to see you here. We got Rocky Water is over there on Locals. Says, here's to Alina and her wonderful vocab. I particularly liked her use of the word abrogation. Chick's got writing and motion skills. I love it. She does have a nice vocabulary. And it's educating me. I'm gonna have to buy some flashcards or something so I can keep up with her motions. We got Rocky Water. Thank you for that. C. John is bringing in 10 new membos. Amazing, C. John. Thanks for bringing in new membos. And hey, new YouTube members, don't forget to grab the Telegram link in the community tab section. We're going over to an after party here in a minute, and then we'll see you tomorrow morning for our members only stream. Whether you're on YouTube or on Locals, we do membo streams in the morning. We're bringing in Indie Gal. C. John is bringing in Old Man GM. Me Ma is here. Spitfire. Justin Y. Anthony. We have that one. H8. We have Sup Forest. We have Archangel. And we have Lexi is in the house. All coming in courtesy of C. John. I think that's Social Justice Warriors. Yeah, that's the other one that I skipped reading. Okay, thank you, C. John, for that one. And then our last one in on the tubes is from Resto Guy, coming in as a supporter, and another real handsome puppy there from Resto Guy as a supporter. Welcome aboard to our new membos. Amazing. Now, let us say hello to our friends on the X platform before we wrap it up and go over to our members only Locals after party on the X. Is anybody joining us on there? We have an amazing Watching the Watchers community on X. We do also stream live on X. And we got 17 viewers. Woo! Yeah, so we got Words. Who's joining us? A couple comments. Words was here saying no streaming on Rumble. Yeah, it looks like it broke. It broke. This is what my Rumble looks like right now. So this was what we tried to do. This is today's show. I tried to schedule it twice. And this one, yeah, the live stream is still dead. And this one, the video is still processing. So yeah, didn't work. So hopefully we're back up tomorrow. We got George is here. We got Sharon the Patriot says Vegas really needs to get in on this word of the week, month of the year thing. Snarky says pregnancies are based on 40 weeks and you can take that to the bank, RG. I'll take your word for it. Pumpkin Marie says, couldn't watch you live on my TV, so I left you streaming on Twitter X. Can't hear what you're saying, but you deserve more live viewers. I'm happy to oblige. Well, thank you, Pumpkin Marie. And we're not being stingy with our likes here. Barbs Loves Alaska says, man, I can't find you on Rumble. I know, I apologize. I don't know what happened. I don't like watching here on X because you can't back up the stream to see what you missed. So we're going to upload everything back over to Rumble. I just couldn't get the live to connect today. And I don't, I think like last week they were under DDoS attack and stuff. Shiloh says, if the media covered these cases as honestly as you and other attorneys do, we wouldn't be in the mess we are in these days. They're sitting back and watching our judicial branch being infiltrated by activists. It's unfortunate that they've been captured to the degree that they have. From Shiloh. Good comment. It is. It's like, I wonder where are the rest of the attorneys? Like the rest of the criminal defense attorneys and stuff. Screaming out about what's happening to the courts. It's like wild. Fred says, no one needs to see or read Trump Truth Social to be angry after reading these trial transcripts. And so great comments from Fred and others over on the X platform. We also have the Watchers community, which we're still trying to figure out, what's happening here, what this is all about. But if you want to join us and connect with other people out there in the wild on the X platform, come check out Watching the Watchers. I think Elon is still building out features and other stuff. So it's a way, it's a way to see each other out there in the wild. So come check us out, watchingthewatchers.locals.com. And that's where we're going to our after party right now, my friends. One other reminder to check out robertgovea.com. So if you saw any documents on the screen that you like, if you want to follow the PDFs and grab those, we post them on robertgovea.com along with the video segments. So we had 3 segments today, so those will be posted there. They're also translated into reports, so they get summarized if you can't watch the full video. Read the summary, get the PDFs, sign up for the daily newsletter if you want all that bundled up and delivered right to your inbox. robertgovea.com is where you can sign up for that. Of course, we'd love it if you subscribed one more time, wherever it is you're watching this. Like this video would also be a very, very appreciated gesture. And before we wrap up and go to our after party, let's say what's up to our mods and our meme smiths who mod down the fort for us and keep things nice and orderly around these parts. Donut Mind Me clipping away for us, along with Dog Digger, Janek 909, John Allen in the house, Zach Nichols. We got Beyond Geo, Zulu's in the house, Ronnie Cole, Playing Hooky, Just Cause, K-Bean, and our friend Vienti Kiss Prime, who I think it's on game night on Mondays or something, V. And then, of course, our meme smiths, Geegum Geegum, Sleepy Dog Lee, and Nathan N810, all modding down the fort for us. And a couple other comments came in before we wrap it up. What's up, Norman Smith? Says, thank God it's Monday. Another great live stream. I feel the same way about that too. Like, I love the holidays. I love spending time with the fam and all that stuff. But there's also business to attend to, and we've got to attend to it. So thank you, Norman, for dropping that one in the house. And Facts Matter says, Rob's Alina is better than Zulu's Saki. Well, that's unequivocal, Facts. That's absolutely unequivocal. Yeah, I mean, it's Alina. It's Alina Abba. Like, come on. What can you say? We got Scott Zajac is here. Thank you, Facts, for the nice tip. That's nice one. We got Scott Zajac is a supporter in the house. Welcome aboard, Scott. And paying a member for 6 months says, mega, baby, make America great again, baby. Good to see you, Peng. A member for 6 months. That's 2/3 of the way to a baby. We're getting closer and closer every day. But okay, my friends, thank you so much for becoming members. Thank you for all the amazing donos. We do try to deliver for our membos. We do streams in the morning. We do Saturday shows. We got some other cool stuff in the works. And so, my friends, that is it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. I would love to see you there, but if not, we will tomorrow. Be back here to get into it all again. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.